Good evening, this is John Milburn. This is Laws 19038, Planning and Environment Law. This is week 2. Tonight we deal with planning and environment law in legal context. We've got a lot to cover, so I'll move fairly quickly. Please use your chat facility to ask a question, or unmute your microphone if you wish to ask a question as we progress. Now, a few things as to where we should be by now. The first is, of course, you should have been through the Moodle site, got a feel for what's involved in the course. You should have received and flicked through your textbook generally. Certainly read the first 3 chapters of environmental law in Australia. I would hope that you've looked at the 2 assessment pieces and worked out a way to upload your assessment. Certainly I'm speaking to the converted now, but registered for Zoom, so you're ready to join us live, hopefully. And if not, look at the recorded sessions. I will provide some hints from time to time in relation to the assessment work, so it's worth looking at the Zoom videos. Certainly I trust that you've enrolled in UCrew and started to discuss. I love people sharing material in UCrew, so don't wait for me. If you come across something that you think is interesting or of value generally to your colleagues or to me, please feel free to upload it. Don't wait for an invitation, and I love to see collaboration and good discussion. So using UCrew is a great way to do that. You hopefully will also find it a good way to meet fellow students, and perhaps from that you can form some study forums or study groups. Certainly I think it's important that you've mapped out your study plan. I like to think that you work backwards, look at what you need to achieve, and then try to systematically work towards that objective. Now, in terms of the presentation of the work, I would suggest to you that it is important to present the material in a way that is consistent with the way lawyers normally present material. And just to give you an idea, I have a sample document which you'll find at the very end of the landing page in Moodle. I'm going to share the screen now so we can look at that document, and now hopefully you can see, amongst other things, my sample document. Now, is that what you can see there? All right, I've just lost you there for a moment, but hopefully you can see that sample document. Now, there's no magic in this particularly, but it's what I like to see. So you can see right away that it's got consistency of spacing, headings are consistent, the font is consistent throughout, and it's got some things in here that are underlined in blue or green or red, and that's always a hint to try and sort them out. So you can use this as a template for your own work if you wish, and I'd encourage you to read it because it provides some actual legal information that might be of value to you as well. Now, in terms of footnotes and referencing, we don't use the Harvard style in this course. If you look at the course profile, it says that we use the Australian Guide to Legal Citations. Now, I want to explain what that means tonight in brief. The first thing you'll note is that unlike Harvard, where there's referencing in the body of the document, using the Australian Guide to Legal Citations, we use footnote referencing. Now, it's really easy to footnote reference. If I go up here, past the word document, and if I want to include a reference there, I simply go to Reference, Insert Footnote, click on that, and you'll see down the bottom, it automatically numbers the footnote. I like to tab away, and then you can just insert the commentary that goes with that footnote. So using footnote referencing itself is really simple to do. In terms of what the content includes, one of the things is that you'll see case law and legislation is typed in italics. There's a couple of little rules that go with it. The name of the case is italicised, but the year of the case and its citation generally is not. If you contrast that to legislation on the second page, you'll see there, Legal Profession Act 2004, the year of the act is italicised, unlike the reference to the case law. When it comes to citing a case, don't provide me with the internet citation, in this instance, the Ostley citation. That's not what we do in legal writing. In legal writing, we write the name of the case as it is cited formally. So Humsey Hancock is in square brackets, close square brackets, QSC 34. And you'll see that in the textbook. So just follow those simple guidelines in terms of the textbook. And if you want to get rid of a reference, just get rid of it like that, and you'll see it's gone back to the automatic numbering. Apart from that, make sure that you indent if you're going to quote something that's more than 3 lines. And in this instance, you'll see that the font size has been reduced by 1 point for that which is indented. I like to keep it uniform. I use Calabri, maybe 11 or 12 font, and make sure you paginate your paper. There's no pompous way of just saying put the page number in and ensure that it's consistent. Now, in terms of the style of writing, legal writing these days is intended to be simple and clear and interesting. And I do like interesting assignments. Look, one way that you can gain my attention and the attention of readers generally is to use short sentences, particularly at the start, and make them interesting. One of my favourite judges is the late Lord Denning, and this is literally how he commenced the decision of Thornton against Shoe Lane Parking in 1971. So Lord Denning was well ahead of his time. And this is how he started the case. The customer pays his money and gets a ticket. He cannot refuse it. He cannot get the money back. He may protest to the machine, even swear at it, but it remains unmoved. And it just encourages you to read on. What's this case all about? So please consider that, and you'll notice that His Honour used very short sentences to good effect. So you don't have to write using long sentences in, using big words to write well. In fact, in many ways, it's quite the opposite. Also, do try to write in the active rather than passive voice, and you'll see some commentary here. So the accused hit the victim. That's the active voice, as opposed to the victim was hit by the accused. That's the passive voice. Now, what you can do is find that in the word program, there's the blue underlining, and that will give you a quick guide as to whether you're in the active or the passive voice. So if we right-click over that, it says, this is passive voice, consider revising it. So please take the hint that Word is offering you there. And indeed, if you see any red, blue or yellow underlining, it's probably a suggestion that you need to consider changing it. If you go to File, Options, Proofing, you'll see that there's some great tools built into the Word program that will enable you to check the grammar and spelling. So this part down here enables you to recheck the document, and you can change it so it's grammar and style or just grammar. You can check for a number of different things, and you can check the settings over here, identifying what you want to check and what you don't want to check. So if you go through that process and recheck it as I've just done then, you will see that it has highlighted a number of things that may require some attention. And also, of course, through proofing and review, you can do the spelling and grammar check, and it will take you through. So there's some really interesting ways and easy ways to get to the heart of what it is that you want to do. All right, so hopefully there's no questions about that. And I'm just racing through that. I finished it. And what you'll see, and what I wanted to show you is, in this document, I've got some readability statistics, and you'll see that passive sentences, the 6%, so it's a very low proportion of the sentences, and the ease is 70, which is excellent, and the Flesch-Kincaid grade level is 6.5. It's really good to have that number low, relatively low. You won't always achieve it that low. Essentially, that means at grade 6, grade 7 reading level. And you might think, oh, we want to write in a more intelligent, sophisticated manner than that. Not necessarily. The idea of communication is to communicate effectively. So if you can get that grade level down, that's an excellent thing. If you've got a grade level of 15, it probably means that the reader is going to have to labour through your document, and that's not conveying the message in the way that we like to convey. So keep those things in mind as a general hint. Now, when it comes to the way in which we reference, you'll see here footnote referencing, Thornton against, and you notice I didn't say versus, I said against, or and is another way of doing it. Thornton and Shoe Lane Parking, 1971, 2 Queen's Bench, 163, and you'll see there's a counterpart reference to the All England reports as well. Pinpoint referencing down here, Miller and Jackson, is Queen's Bench 966 at 976. What that means is that this particular quote, which is number 8, occurred at page 976. We call that pinpoint referencing. Now, there's a bit to take in, particularly for non-law students, and I am encouraging you to write in a way which is that of law students. So one thing you can consider is this. At the tail end of the landing page of your Moodle site, we have this thing here called Guide to Citation of Sources, Writing Style and Assignments. This is from the University of Queensland. Now, I've already called it up. You should see it there from the TC Burns School of Law, which is where I studied. And it's a really quite a very simple, quite short document that explains referencing in an assignment. I would urge you to read that. If you want to look at the Australian Guide to Legal Citations, by all means you can, but it's a very lengthy document, the actual guide itself. So for our purposes, to get you through the assignments, have a look at the Guide to Citation of Sources in Assignments from the my old law school, and it'll have some valuable and easy to read information that you can incorporate briefly and professionally into your assignment work. I'll leave you to read that for yourself. I won't go through that in any more detail unless anyone has a question. And I'm just going to sorry, what am I going to do? Stop the share for a sec and go to gallery view. Hi everyone. Now, has anyone got a question about anything that we've done so far? No? All right, well, I'll just go back to speaker view. And now there's a little pop-up has occurred, exactly where I'm trying to get to. All right, now I'm going to go back to share documents because I want you to have a look at the first assignment. And I'm sure that you have already. I better get rid of that. That's not what I want to see. Now let's go to the first assignment. And this is due on the 28th of April, 2016. All right, so can you see that now? I'm just calling up the first assignment. It's a bit slow. And I take it you've all had a read of that. So we've got the assessment work due on the 28th of April at 11:45 p.m. All of my assessment work is due on a Thursday. It's a standard practice of mine. And in every instance of an assignment work with me, you must submit your work by the following Saturday of the week after. So if you're more than 10 days in submitting your assignment, it will automatically be marked as 0. So make sure you get it in. As I mentioned last week, you will lose 5% per day if you're late. You won't get an assignment extension easily at all. If you tell me in the week of the assessment that you're really busy and you're not well and things have happened in your life that are really awkward, I'll say something like, I knew in week 1 that you'd be busy and I knew you had lots of things in your life and you've had plenty of time to do the assignment. So build in some insurance there by getting it in, or at least having it ready to go, even if you don't submit to the last minute in case you're not feeling too good on that day. Sorry, I'm a bit tough when it comes to extension requests, but I like to set out the guidelines right from the start. Now, this assignment is really quite simple. You don't have to get bogged down in it. It's there's not a lot of difficulty in it, except the last part of Predajon, which is worth 10 marks. This is where I'm really going to sort out the people that are getting their 5s and 6s and 7s, and it's to do with a hypothetical appeal. This is the real thinking part of the assignment. So the first 15 marks are pretty easy to get. You need to understand the case, explain the rules, explain how the judge came to his decision, and that's all pretty straightforward. But then I'm going to ask you this. All right, what if you decided your client wanted you to go to the Court of Appeal? What's involved in that process? That will require you to do a bit of forward reading in your materials and you'll need to understand the difference between the Planning and Environment Court and the Court of Appeal. So we talked about a court hierarchy. The Planning and Environment Court is really at district court level. The Court of Appeal is one of the two divisions of the Supreme Court, and if a party is unsatisfied with a decision in the Planning and Environment Court, then they may attempt to have the matter considered on appeal in the Court of Appeal. However, as a hint, you don't always have an automatic right to go to the Court of Appeal, and it's in the question, but you need to apply for leave to appeal. So I'm really keen for you to tell me what's involved in that process, and if you were to argue leave to appeal to the Court of Appeal, give me 1 or 2 or 3 or 5 different reasons why you might be able to do that. So that's the thinking part of that assessment. And the second part relates to the legislative basis for the Commonwealth to pass environmental laws. That's pretty straightforward. And the third part relates to a directions paper issued by the Department of Infrastructure, Local Government and Planning. So I've given you the legal citation or the reference there. I haven't given you a reference to how to find the Predajon case. Part of your task in this course is to find your way to legislation and case law. So that's why I haven't given you the direct link, and excuse me for that. Okay, so when it comes to the first assessment, you might need to consider how to go about writing your material. And one of the ways I do it is to, and this is an acronym, you might like to take this down, it's CMIRAC. Now, what it stands for is this: conclusion, material facts, issues, legal issues, the legal rules, that's the R, A is the application, and C is the conclusion again. So if, for example, I'm arguing a case in front of a judge, I may go about presenting my argument in this fashion. I might say, Your Honour, ultimately my conclusion will be this. I would urge Your Honour to consider 1, 2 and 3 as the material facts for consideration in this case. In my submission, they are the material issues or the facts that we must consider. I would then say, Your Honour, I submit that there are 3 legal issues relevant to Your Honour's consideration, the A, B and C. I would then say, Your Honour, I submit that there are 2 rules, legal rules that apply that deal with these legal issues that have arisen. That is, this statute and this law form the basis of the legal rules for Your Honour's consideration. I would then go on to submit how those legal rules relate to the issues and the facts, in other words, how they're applied. I would say, well, this legislation is applicable to this issue in these material facts for this reason, and then I would come back to my conclusion, which I'd earmarked at the start. So if you're struggling to work out how to go about structuring a legal paper, then maybe think of that acronym. You don't have to put in those headings. You don't have to stick to exactly that format. But law students use that type of legal, logical thinking when they're both preparing a written assessment or presenting some assessment or some presentation in court. So keep that in mind. Now, I do expect you to reference your material, use the Australian Guide to Legal Citation. Remember that there are word limits, and I do expect you to stick to the word limits within reason. If you're a little over, don't worry about it. I'm not going to mark you down. But if you're over and you've padded, then I'm not going to give you extra rewards for that by any means. If you're well over the word limit, and when I say well over, say 10%, if you're more than 10%, I'm starting to look at it and say, have you used your words efficiently? Because if you haven't used your words efficiently, then you're not going to achieve the same sort of mark. And if you're well over that limit, then you know, I'll either stop reading or I will mark you down because it's not the way to do things. I'd rather you were just a little under the word limit than way over the word limit. But if you're a little over the word limit, that's fine. Don't stress over it. One thing I do is I won't mark draft assessments. So please submit your assessment in final form and upload it in Word document, preferably, through Moodle as your final assessment. You don't have to tell me that you've lodged it. I monitor that regularly and I'll be able to see that. Now, of course, we use UCrew on a different topic for our online discussions, and if you've got a question, generally you'd ask that of me through UCrew, but please don't wait for an invitation. If you come across something that's interesting, if you come across a link or a fact or an article, then share it. It's great karma to share, and I will be very pleased to see you collaborating and helping each other. So please use UCrew for that. Now, I'm sure that you've all read Chapter 1 and Chapter 2 of Bates, and I'd like you to keep up with your reading and be ahead of your reading. Now, I'm not going to repeat what I've already said in my two-camera session in relation to Chapter 2 of Bates, but I'll just highlight a few of the important areas. The first, of course, is you need to understand the doctrine of separation of powers. Now, law students understand this pretty quickly. It's pretty basic. Parliament makes the legislation. The executive deals with the administration, and the judiciary, the courts, deal with the interpretation and legal disputes. So that's the basic hierarchy, the three-tiered hierarchy for our form of democracy. Ideally, or theoretically, they're supposed to be separate. The first two aren't really that much separate. There is a crossover. For example, a minister is actually both in Parliament and part of the executive. So there are some crossovers. The judiciary really stands quite firmly independently rather than the other two. Bear in mind that when you're studying planning and environment law, all three levels of government provide something towards the rules, if I can use that term, of environmental law or planning and environmental law. The first is Parliament creates legislation. Commonwealth, EPBCA, State, SPA, for example. Environment Protection and Biodiversity Conservation Act and the Sustainable Planning Act. So legislation is pretty obvious. That's what Parliament does. Courts provide common law precedent. So if the High Court comes out with a decision, say Mabo, then that becomes part of our law. And courts that follow, if they're lower in the chain of the hierarchy, are required to follow the previous decision that was made in a previous court case. So that's what we call common law or precedent, the doctrine of precedent. Now, in the middle, we have the executive, and the executive has no power conferred upon it through constitution. Any power that it has comes via Parliament, and that form of power can sometimes be in the form of delegated legislation, which is really interesting because delegated legislation is where Parliament, for whatever reason, maybe because Parliament is busy or there are changing circumstances, whatever it might be, enables the executive to make rules that are legally binding in circumstances where the executive otherwise doesn't have power to do so. And this delegated legislation is usually in the form of bylaws, regulations, rules, ordinances, things of that nature. So you'll see a lot of that in planning and environment law. So bear in mind that's the executive that creates that after it had been given power to do so by Parliament. So when you're considering planning and environment law, you're considering law created at all three levels, and you need to understand how they interplay and how they work. Now, there's a couple of basic rules. Legislation overrides case law, so it's like playing 500 or euchre or something. It's a trump card. So legislation overrides the case law. Case law becomes part of the law through this doctrine of precedent that I mentioned before. And when you're considering the executive, you need to also consider this concept of the Crown. Now, have you come across that? Have you come across statements of what, the Crown? You might have seen a statement that says, this act is binding on the Crown. Anyone seen that? All right. Now, of course, if you come across that piece of legislation, you need to understand what the Crown is. A couple of things about the Crown. The first is that when a person owns freehold land, they don't actually own everything to do with that land. For example, they don't have the natural resources, minerals and petroleum. Those things are reserved to the Crown, and the freehold is for the other things that go with the title. So private ownership doesn't include ownership of the natural resources. So that, for that reason, when we're thinking about planning and environment law, bear in mind that the owner of property may still be subject to mining leases that might be imposed upon that property. And that's because the reservation on the title is to the Crown for mining leases, for mining and petroleum. So let me try to explain the concept of the Crown. The way I like to think of it is that the Crown is to Australia what the household is to a family. Let me see if I can describe that better. Let's take a household. You've got mum and dad and two kids. They're the people in the house. They're the ones that occupy, and collectively they are the household. But the people within the household come and go. Kids might grow up, mum and dad become empty nesters. It's still a household. It's just that the personnel have changed, if you know what I mean. And indeed, I suppose, the house could change ownership and a different household could come in. So when we talk about the Crown, it's something that is there permanently, as opposed to governments that come and go every time there's an election. And the executive, they administer and they're responsible for the affairs of the Crown, but they are not the Crown, if you understand that concept. So that's about as good as I can explain it. If you've got any questions or you've come across a better way to describe it, please feel free to raise that through UCrew. All right, now it's all very well to say we've got this separation of powers, but how is that effective, or how does that manifest itself in planning and environment law? Well, if you look in the Queensland context at the Sustainable Planning Act, and I'd urge you to do that now if you haven't already done so, the Sustainable Planning Act 2009 provides detail about the management of the process by which development occurs. So it talks about how state, regional and local planning documentation is put in place to regulate the planning process. Okay, so Parliament creates the state, regional and local planning documents. The executive is conferred power through delegated legislation to create ordinances, rules, bylaws, etc. And also the executive, apart from creating those laws, has a role to assess and administer and deal with development applications. So it's the executive that deals with planning applications. And those applications pursuant to the State Sustainable Planning Act are done in accordance with the Integrated Development Assessment System process, IDAS. A lot of acronyms to get used to. So think about IDAS is the Integrated Development Assessment System. It is a process that's incorporated into the Sustainable Planning Act. And if you want to get an idea of, just by way of definition for IDAS, have a look at section 230 of the Sustainable Planning Act. That'll give you an idea of this process by which applications for development are assessed. Now, if a development is an impact in assessable development, then an applicant may refer a dispute to the Planning and Environment Court. So I know we're moving quickly, but when you're reading through the IDAS procedures and you're thinking about how can I challenge something that I'm not happy with, bear in mind that not every development application can be taken to the Planning and Environment Court for a submitter, for an objector. It needs to be an impact assessable development. And those terms will become more apparent as we proceed. All right, are there any questions so far? You're doing really well. You're staying with me. I know I'm moving fast. Look, in Bates, you would have seen a lot of commentary in relation to overcoming private rights and the issue of compensation for acquisition of property. So there is in the Constitution, Section 51, subsection 31, the requirement for the Commonwealth to pay for acquisition of property on just terms. You know, just like in the castle. And the task is to determine what is property, because the obligation to pay compensation on just terms is where there is an acquisition of property. So there might be an argument about what's property. And in a planning and environment law context, bear in mind that a person who has water flowing through their property may not have property in the water that flows through it, if you understand what I mean. So what that means then is that if there are some licensing regimes that have an adverse effect on that person's ability to access the water, it may be that that person cannot claim compensation because the government has not acquired property by restricting the flow of water. So have a look at the decision in Environment Protection Authority against Rashley. Also look at the decision of the High Court in ICM Agriculture against the Commonwealth, where the approach in the earlier case was upheld. And then finally, in Arnold's case, Arnold against Arnold against Minister Administering the Water Management Act, that's 2010, High Court of Australia, HCA number 3. And in that case, the High Court held that aquifer licences do not constitute an acquisition of property. So the point is that sometimes it can get confusing as to when a person is or is not entitled to obtain compensation for the acquisition of property. Courts often see themselves as protecting the rights of property owners. Sometimes the governments try to avoid the whole issue of just terms compensation by introducing structural adjustment schemes. And you'll see there's some commentary there. And at 2.42 of the commentary in Bates, the author talks about Spencer's case, which is important, and it highlights the situation where sometimes people are adversely affected by a decision. They can't claim just terms compensation, but as Justice Rothman says, what that essentially means is that that particular person is being asked to pay for the benefit of society generally when they suffer a particular loss and they don't receive compensation for it. So that issue is a really curly one, and it's one that you might want to try and understand into the future. Now, I know I tried to make my presentations 25 minutes. I've already gone past that. And bear in mind, if you have any questions, please let me know. But also, when you're doing your reading, have a look at environmental law and Indigenous Australians, just to have an understanding of three things. Understand, in brief, the Mabo decision, understand Native Title Act, and understand the Wik People's decision. If you can just get a basic understanding of those three, then it will all fit into place nicely. There's plenty of commentary on it. Bates has an excellent commentary. You really don't need to go beyond Bates when thinking about that. But just remember, of course, that as a result of the Mabo decision, that is Mabo number 2, the federal government enacted the Native Title Act in 1993, and ultimately the present position is therefore that Australia was not terra nullius at the time of British settlement, as was presumed to be the case prior to 1992. I've moved through that really quickly, but hopefully you can do the reading and get a basic understanding of that. All right, now, each week or most weeks, I'd like you to show you some places to access legislation and commentary. So once again, I'm going to share the screen, and you should now see my desktop. And let's have a look at Commonwealth. This is the ComLaw website, www.legislation.gov.au. You can access it by www.comlaw.gov.au as well. And this is where you can find up-to-date federal legislation. It's authorised commentary, and it has information about how to read legislation, which is really useful. It has information about Gazette information, announcements, and information about bills. So if you have any concerns about Commonwealth legislation, then this is a great place to start your search. At a state level, we have Queensland legislation at www.legislation.qld.gov.au. And again, this is authorised commentary in Queensland, provides up-to-date legislation, provides information about repealed information and bills. There's a search facility, and it's really a terrific resource available to you. So I would urge you to look at that. The next one that I want to show you is Australia. This is one of my particular favourites. Australia is an excellent place to look for Queensland legislation. It's not authorised, but it is still very authoritative. It does contain a combination of Commonwealth and state materials. It has law site facility, which is a terrific way to have a look for case law. You'll see that up there. It has a note up search, which is excellent. So, for example, in note up, if we go to Queensland, we go to the Consolidated Acts, the Sustainable Planning Act, which is here, and we go to, say, Section 8, which deals with ecological sustainability. If we go into Note Up, it will have a list of some cases that relate to that section. So if you want an up-to-date case on Section 8, here's one, Lockyer Valley, which was 2015, Queensland Planning and Environment Court 15. So that's less than a year old, that particular case. So Australia has a great lot of resources, and I'd urge you to consider that. Also, Barnett Jade is terrific. I love Barnett Jade. This is a really good resource. Once again, it's unauthorised, but it's still very popular. It incorporates authorised reports, has a good search guide. You can use the Jade browser. I would just urge you to have a look at these websites and get a feel for them. Now, really importantly with Jade, it has a sign-up service where you can register for free, and as a result of that, you can obtain straight to your phone or tablet or computer the most recent and up-to-date cases on a particular topic. So every day I get an update from Jade, and it says, look, you're interested in environmental law, here's a decision from the High Court from yesterday, or the Planning and Environment Court from yesterday. So it's a great way to keep up to date. And could you imagine if you put in a case in your assessment piece, which is only a week old? Wouldn't that be great? Now I'm going to stop the share now. So thanks for your patience. You've been bearing with me very well. What I propose to do each week is, if we can, time permitting, have a look at the weekly assessment. What I notice is that at this stage, no one has made an attempt at the weekly assessment for this week, but we'll talk about that next week. All right, so I know that's been pretty quick. Are there any questions or comments before we wrap up for this evening? You've all done very well. Okay, thank you. All right, well, I'll stop the recording now. Thanks for joining us, and we'll see you next week.